When you agree to arbitration, you are waiving so many rights you would otherwise have if you didn't arbitrate.
Right. Once the story broke, we're like, what the hell is this?
You go to Disney World and you eat at a restaurant. Again, to be fair, it's not a Disney-owned restaurant or a managed restaurant. It's a restaurant that is
Disney Springs.
Disney
It's not in the
Springs,
park or anything. Yeah.
No, it's on Disney property. So, it's this old idea, Ron, of, the deep pockets, right? When you're going to file a lawsuit like this, you go after the deep pockets. And if there's some type of tacit legal connection, you're going to make the connection and try to go after the big dog. In this case, the big dog's Disney.
Well, we also don't know exactly why they're including Disney. There may be some reason that's outside of our purview.
In theory,
and I've heard that argument come out too, right? Once the story broke, we're like, what the hell is this? And obviously some people gave some feedback. They're like, hey, it's actually Disney's more of like a landlord in this situation. And I've been to that restaurant a couple times, by the way. It's a fun place to go have a drink or have a meal.
or get an
My question would be, if you're Disney and that's your position, is like, hey, we're the landlords, like blah, blah, blah. Why are you filling your defense for this? Your pushback against this suit as the Disney Plus terms of service that you signed up for, as opposed to, hey, we're just the landlords. This should not be in our purview, blah, blah, blah.
That's the question, right? And this is what I want to hear Ron's opinion on. You bring up something, they're landlords. Why are you suing us? But I mean, I can tell you, as somebody that has several commercial leases for businesses that I operate, my wife operates, there's a lot of times when you sign a lease, the landlord is also going to compel you in that lease. Number one, you have to have liability insurance. And number two, a lot of times you have to have as a named insured in your liability policy, the landlord as well, for exactly this kind of thing. So that if something happens,
I hate to tell you this, if you're not aware of it, I'm certain that you also agreed to indemnify and hold harmless the landlord for any lawsuit arising from allegations or claims involving your conduct. So that's the substantive defense that Disney should be making. But someone had the bright idea.
Yes.
Hey,
go for it, Ron.
Hey, we don't even have to go. We don't even have to get that far. We can get this into arbitration.
This was $10 says this was a young guy, Ron. Somebody had a theory.
Yeah. What? But someone authorized it, and my God, what a oh my gosh,
horrible PR. It cost them more in PR than it would ever cost to pay it out.
There's a two-step process here. One is that the arbitration clause in Disney Plus, in the Disney Plus trial, says anything arising out of, and then there's this very broad list of things, but all of them have something to do with Disney Plus, not with eating in a restaurant or not.
Well, what's funny about this, Ron, is that in this article, if you scroll down here, it actually talks about other companies that have been able to pull this, basically, and that's what I found interesting about this article here.
Yeah, I'm going to scroll down in a second on that. But yeah, I mean, in this case, and what we're talking about for those that may not be totally familiar is that you had a gentleman and his wife dined at this restaurant in Disney Springs. And that's key, not a Disney park, not something that is ticketed. Because one of the defenses that Disney also raises in this is also that they bought a ticket to Epcot, okay? They weren't in Epcot. They weren't in a ticketed park. They were just at a public Disney Springs venue. When I say public, in the sense that anybody can go to Disney Springs without buying a park ticket. It's a shopping center and restaurants and all this kind of stuff. And they're saying, and Disney is saying, that this couple, the wife who suffered an acute allergic reaction, passed away after being served food that contained items in the dish that she allegedly specifically told the restaurant that she was allergic to. She can't eat this and that. She was served that anyway. They did not comply with the request, allegedly. And she suffered an acute allergic reaction, and this poor lady passed away. The husband is now suing among others, involved in this. The restaurant itself, of course, but also the Walt Disney Company, Walt Disney World, is being the landlord. And Disney is saying, you can't come after us because you signed up for Disney Plus in 2019.
Just a trial, actually.
This is the defense that Disney is headlining with. This is what Ron is. This is the stupidest thing. And the guy, according to the reports here on the lawsuit, the guy was only seeking, and again, I know it's not everything, and we talked about this Wednesday, there could potentially be, if they're found liable, you could see punitive damages, although I don't know how Florida's laws work in that regard, but I think he was going after, like, he listed $50,000 was the damage.
That was just a jurisdictional statement. That's just to get him into that level of trial court.
They want a jury to find them liable and the jury to decide how much to award. That's just like the 50,000 is a baseline, if I'm not misunderstanding.
Yeah. And I mean, even at that pace, you think about this, I mean, obviously it seems more apropos for Disney to try to settle this thing without it going to court, because it just looks bad no matter what. Now, granted, if it is a purely frivolous lawsuit, if it's found that way, that's another thing. And I understand companies wanting to defend themselves against such frivolous action, but it's the defense that Disney put up, at least that made it out publicly, of you bought a Disney Plus subscription back in 2019, so therefore nana nana boo boo, stick your head in poo poo, right? This is the argument that Disney's making, and
there's another really important point here, which is that, and legal. I got to give a heads up to Legal Bites, because she went through this very thoroughly, but she didn't make quite the point that I'm about to make. Another somewhat closer point that she said they've got a little bit stronger argument on the fact that whoever buys tickets, that the arbitration agreement is binding on you and whoever you buy tickets for, which makes sense because people buy tickets for the whole family.
Right. This was the Epcot ticket they brought up. Yeah.
But when you buy a ticket, when you agree to arbitration, you are waiving so many rights you would otherwise have if you didn't arbitrate. Courts are extremely reluctant to impose arbitration on you where you have not yourself consciously agreed to the arbitration. So much so that in our retainer agreements, we have a special section that people have to sign saying, I read the arbitration agreement, I get it. We get that there's an arbitration agreement, because otherwise a lot of courts will not enforce it. So if it's a matter of children, you're buying tickets for a whole family, so the parents are going to be the ones to give that permission or refuse to give that permission. But if it's a husband and wife, both of whom are adults, obviously, very, very unlikely that a court is going to. And besides, as you pointed out, and as Legal Bites pointed out, that still really has nothing to do with the case here. There's a list of what they're responsible for, and has nothing to do with this.
So let me toss some ideas out here, because people have said, why is Disney even in this lawsuit? And if they are in the lawsuit, why aren't they just saying, well, we're not this business. We don't have anything to do with this. Why are you suing us? And I would just toss this out here. And these are theories because I don't know, so I'm speculating. But what if the medical response was slow and the plaintiff believes that Disney is to blame for that? What if there are protocols in place that Disney requires of all of their restaurant owners within Disney Springs regarding allergens, and they believe that, Disney did something wrong here? Those are just, there are ways that Disney can be involved in that we haven't thought about.
I was going to say, I may have at least a speculation as to where Disney may have more involvement here. I think that the reason they picked this restaurant, if I'm not mistaken, from the story I remember reading initially, was that in the Disney, I don't know if it was on an app or in one of their brochures or something like that, this was one of the restaurants they recommended for people with allergy problems.
Oh my gosh.
That's my point. Yeah, so I wonder if that maybe will be a big point here. Yeah.
Chameleon strikes for 5. Some say Disney is not culpable as they don't own or operate the business, but then why not use that argument? Isn't using Disney Plus and terms and conditions an admission of culpability? Ron, thoughts on that one?
Well, they will use that argument, but if you can if you can avoid having to make the legal argument by getting into arbitration, you've taken it away from a jury. So it's just a kind of the belt and suspenders thing to do, except here that it's not a belt. It's a shoelace.
Puck for 5 says, is it true that Disney is simply the landlord and not the owner of the restaurant? It's not a Disney-owned restaurant as far as I know. No, it's not. This is not in a park. This is not a Disney-operated restaurant or anything like that. This is strictly a landlord-tenant relationship on Disney property, granted, in Disney Springs, which is not a ticketed park. But like we mentioned, and I know this super chat came in a little while ago, but that's why I mentioned that even in such commercial leases, I've got 3 or 4 commercial leases myself, between myself and my wife, and every one of them commands liability insurance, and you have to name the landlord as a named insured on that liability policy that you as the tenant are expected to purchase and maintain for exactly this sort of reason. The landlord, basically, it's so the landlord, like, if you're gonna come in and you're gonna operate a, let's take the extreme example, you're gonna operate a meth lab in here, and we get hauled into court, we aren't paying for your stupidity, right? That's kind of the extreme example, but this is why they put this kind of stuff in here. Make sure you're subscribed to Valiant Renegade and join us every Sunday at 6 p.m. Eastern for the live show.